So now let's talk about Rule 114, bail. Again, this is Study With Me sesh because this is a remedial law. So lahat sa remedial law playlist would be a Study With Me sesh. Same format dun sa previous videos. First codal, and then discussion, and then bar cues. And we will be basing it sa Bar Syllabus for 2024. So yung sabi dito about bail is just, bail, Rule 114, Recognizance Act of 2012. That's it. So Rule 114, bail. Section 1, bail defined. Bail is the security given for the release of a person in custody of the law, furnished by him or a bondsman, to guarantee his appearance before any court as required under the conditions hereinafter specified. Bail may be given in the form of corporate surety, property bond, cash deposit, or recognizance. Section 2. Conditions of bail. Requirements. All kinds of bail are subject to the following conditions. The undertaking shall be effective upon approval, and unless cancelled, shall remain in force at all stages of the case until promulgation of the judgment of the regional trial court, irrespective of whether the case was originally filed in or appealed to it. The accused shall appear before the proper court whenever required by the court or these rules. The failure of the accused to appear at the trial without justification and despite due notice shall be deemed a waiver of his right to be present thereat. In such case, the trial may proceed in absentia, and the bondsman shall surrender the accused to the court for execution of the final judgment. The original papers shall state the full name and address of the accused, the amount of the undertaking, and the conditions required by this section. Photographs, passport size, taken within the last 6 months showing the face, left and right profiles of the accused must be attached to the bail. Section 3. No release or transfer except on court order or bail. No person under detention by legal process shall be released or transferred except upon order of the court or when he is admitted to bail. Section 4. Bail as a matter of right. Exception. All persons in custody shall be admitted to bail as a matter of right, with sufficient sureties, or released on recognizance as prescribed by law or this rule, before or after conviction by the Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court, and before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Section 5. Bail when discretionary. Upon conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal, provided it has not transmitted the original record to the appellate court. However, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed with and resolved by the appellate court. Should the court grant the application, the accused may be allowed to continue on provisional liberty during the pendency of the appeal under the same bail, subject to the consent of the bondsman. If the penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied bail, or his bail shall be cancelled upon a showing by the prosecution with notice to the accused of the following or other similar circumstances: that he is a recidivist, quasi-recidivist, or habitual delinquent, or has committed the crime aggravated by the circumstance of reiteration, that he has previously escaped from legal confinement, evaded sentence, or violated the conditions of his bail without valid justification, that he committed the offense while under probation, parole, or conditional pardon, that the circumstances of his case indicate the probability of flight if released on bail, or that he is undue risk that he may commit another crime during the pendency of the appeal. The appellate court may, motu proprio, or on motion of any party, review the resolution of the regional trial court after notice to the adverse party in either case. Section 6. Capital offense defined. A capital offense is an offense which, under the law existing at the time of its commission and of the application for admission to bail, may be punished with death. Section 7. Capital offense or an offense punishable by reclusion perpetua or life imprisonment, not bailable. No person charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment shall be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. Section 8. Burden of proof in bail application. At the hearing of an application for bail filed by a person who is in custody for the commission of an offense punishable by death, reclusion perpetua, or life imprisonment, the prosecution has the burden of showing that evidence of guilt is strong. The evidence presented during the bail hearing shall be considered automatically reproduced at the trial, but upon motion of either party, the court may recall any witness for additional examination unless the latter is dead, outside the Philippines, or otherwise unable to testify. Section 9. Amount of bail. Guidelines. The judge who issued the warrant or granted the application shall fix a reasonable amount of bail, considering primarily but not limited to the following factors: financial ability of the accused to give bail, nature and circumstances of the offense, penalty for the offense charged, character and reputation of the accused, age and health of the accused, weight of the evidence against the accused, probability of the accused appearing at the trial, forfeiture of other bail, the fact that the accused was a fugitive from justice when arrested, and pendency of other cases where the accused is on bail. Excessive bail shall not be required. Section 10. Corporate surety. Any domestic or foreign corporation licensed as a surety in accordance with law and currently authorized to act as such may provide bail by a bond subscribed jointly by the accused and an officer of the corporation duly authorized by its board of directors. Property bond. How posted? A property bond is an undertaking constituted as lien on the real property given as security for the amount of bail. Within 10 days after the approval of the bond, the accused shall cause the annotation of the lien on the certificate of title on file with the Registry of Deeds if the land is registered, or if unregistered, in the registration book on the space provided therefor, in the Registry of Deeds for the province or city where the land lies, and on the corresponding tax declaration in the office of the provincial, city, and municipal assessor concerned. Within the same period, the accused shall submit to the court his compliance, and his failure to do so shall be sufficient cause for the cancellation of the property bond and his rearrest and detention. Section 12. Qualifications of sureties in property bond. The qualifications of sureties in a property bond shall be as follows. Each must be a resident owner of real estate within the Philippines. Where there is only one surety, his real estate must be worth at least the amount of the undertaking. If there are two or more sureties, each may justify in an amount less than that expressed in the undertaking, but the aggregate of the justified sums must be equivalent to the whole amount of the bail demanded. In all cases, every surety must be worth the amount specified in his own undertaking, over and above all just debts, obligations, and properties exempt from execution. Section 13. Justification of sureties. Every surety shall justify by affidavit taken before the judge that he possesses the qualifications prescribed in the preceding section. He shall describe the property given as security, stating the nature of his title, its encumbrances, the number and amount of other bails entered into by him and still undischarged, and his other liabilities. The court may examine the sureties upon oath concerning their sufficiency in such manner as it may deem proper. No bail shall be approved unless the surety is qualified. Section 14. Deposit of cash as bail. The accused or any person acting in his behalf may deposit in cash with the nearest collector of internal revenue or provincial, city, or municipal treasurer, or the clerk of court where the case is pending. The amount of bail fixed by the court or recommended by the prosecutor who investigated or filed the case. Upon submission of a proper certificate of deposit and a written undertaking showing compliance with the requirements of Section 2 of this rule, the warden or person having custody of the accused shall release him without necessity of further order from the court. The money deposited shall be considered as bail and applied to the payment of fine and costs, while the excess, if any, shall be returned to the accused or to whoever made the deposit. Section 15. Recognizance. Whenever allowed by law or these rules, the court may release a person in custody on his own recognizance or that of a responsible person. Bail. Section 16. Bail when not required. Reduced bail or recognizance. No bail shall be required when the law or these rules so provide. When a person has been in custody for a period equal to or more than the possible maximum imprisonment prescribed for the offense charged, he shall be released immediately, without prejudice to the continuation of the trial or the proceedings on appeal. If the maximum penalty to which the accused may be sentenced is destierro, he shall be released after 30 days of preventive imprisonment. A person in custody for a period equal to or more than the minimum of the principal penalty prescribed for the offense charged, without application of the indeterminate sentence law or any modifying circumstance, shall be released on a reduced bail or on his own recognizance at the discretion of the court. Section 17. Bail, where filed. Bail in the amount fixed may be filed with the court where the case is pending, or in the absence or unavailability of the judge thereof, with any regional trial judge, metropolitan trial judge, municipal trial judge, or municipal circuit trial judge in the province, city, or municipality. If the accused is arrested in a province, city, or municipality other than where the case is pending, bail may also be filed with any regional trial court of said place, or if no judge thereof is available, with any metropolitan trial judge, municipal trial judge, or municipal circuit trial judge therein. Where the grant of bail is a matter of discretion, or the accused seeks to be released on recognizance, the application may be filed only in the court where the case is pending, on trial or appeal. Any person in custody who is not yet charged in court may apply for bail with any court in the province, city, or municipality where he is held. Section 18. Notice of application to prosecutor. In the application for bail under Section 8 of this rule, the court must give reasonable notice of the hearing to the prosecutor or require him to submit his recommendation. Section 19. Release on bail. The accused must be discharged upon approval of the bail by the judge with whom it was filed in accordance with Section 17 of this rule. When bail is filed with a court other than where the case is pending, the judge who accepted the bail shall forward it, together with the order of release and other supporting papers, to the court where the case is pending, which may, for good reason, require a different one to be filed. Section 20. Increase or reduction of bail. After the accused is admitted to bail, the court may, upon good cause, either increase or reduce its amount. When increased, the accused may be committed to custody if he does not give bail in the increased amount within a reasonable period. An accused held to answer a criminal charge who is released without bail upon filing of the complaint or information may, at any subsequent stage of the proceedings, and whenever a strong showing of guilt appears to the court, be required to give bail in the amount fixed, or in lieu thereof, committed to custody. Section 21. Forfeiture of bail. When the presence of the accused is required by the court or these rules, his bondsmen shall be notified to produce him before the court on a given date and time. If the accused fails to appear in person as required, his bail shall be declared forfeited and the bondsmen given 30 days within which to produce their principal and to show cause why no judgment should be rendered against them for the amount of their bail. Within the same period, the bondsmen must produce the body of their principal or give the reason for his non-production, and explain why the accused did not appear before the court when first required to do so. Failing in these two requisites, a judgment shall be rendered against the bondsmen, jointly and severally, for the amount of the bail. The court shall not reduce or otherwise mitigate the liability of the bondsmen unless the accused has been surrendered or is acquitted. Section 22. Cancellation of bail. Upon application of the bondsman with due notice to the prosecutor, the bail may be cancelled upon surrender of the accused or proof of his death. The bail shall be deemed automatically cancelled upon acquittal of the accused, dismissal of the case, or execution of the judgment of conviction. In all instances, the cancellation shall be without prejudice to any liability on the bail. Section 23. Arrest of the accused out on bail. For the purpose of surrendering the accused, the bondsman may arrest him, or upon written authority endorsed on a certified copy of the undertaking, cause him to be arrested by a police officer or any other person of suitable age and discretion. An accused released on bail may be rearrested without the necessity of a warrant if he attempts to depart from the Philippines without permission of the court where the case is pending. Section 24. No bail after final judgment. Exception. No bail shall be allowed after a judgment of conviction has become final. If before such finality the accused applies for probation, he may be allowed temporary liberty under his bail. When no bail was filed or the accused is incapable of filing one, the court may allow his release on recognizance to the custody of the responsible member of the community. In no case shall bail be allowed after the accused has commenced to serve sentence. Section 25. Court supervision of detainees. The court shall exercise supervision over all persons in custody for the purpose of eliminating unnecessary detention. The executive judges of the regional trial court shall conduct monthly personal inspections of provincial, city, and municipal jails and the prisoners within their respective jurisdictions. They shall ascertain the number of detainees, inquire on their proper accommodation and health, and examine the condition of jail facilities. They shall order the segregation of sexes and of minors from adults, ensure the observance of the right of detainees to confer privately with counsel, and strive to eliminate conditions inimical to the detainees. In cities and municipalities to be specified by the Supreme Court, the municipal trial judges or municipal circuit trial judges shall conduct monthly personal inspections of the municipal jails in their respective municipalities and submit a report to the executive judge of the regional trial court having jurisdiction therein. A monthly report of such visitation shall be submitted by the executive judges to the court administrator, which shall state the total number of detainees, the names of those held for more than 30 days, the duration of detention, the crime charged, the status of the case, the cause for detention, and other pertinent information. Section 26. Bail not a bar to objections on illegal arrest, lack of or irregular preliminary investigation. An application for or admission to bail shall not bar the accused from challenging the validity of his arrest or the legality of the warrant issued therefor, or from assailing the regularity or questioning the absence of a preliminary investigation of the charge against him, provided that he raises them before entering his plea. The court shall resolve the matter as early as practicable, but not later than the start of the trial of the case. So that's it for Article 114 Codal, and then the next part of the video would be discussion. Okay, so bail. Wala namang sinabi kung ang topic sa bail, so pasadahan lang natin lahat. What is bail? Bail is a security given for the release of a person in custody of the law, furnished by him or a bondsman. Yun yung kapag wala kang pera, kaano ka muna yung may ibang magbabayad ng amount. To guarantee his appearance before any court is required under the conditions hereinafter specified. So kapag hindi ka nagpakita, kukunin yung pera mo. Para siyang deposit, para siyang collateral. Ganun. So the purpose is to relieve an accused from imprisonment until his conviction and yet secure his appearance at the trial. So this is a constitutional right. To honor the presumption of innocence until his guilt is proven beyond reasonable doubt, and to enable him to prepare his defense without being subject to punishment prior to the conviction. A person is allowed to petition for bail as soon as he is deprived of his liberty by virtue of his arrest or voluntary surrender. An accused need not wait for his arraignment before filing a petition for bail. Kinukulong na kasi yan kahit before judgment to ensure your appearance at trial. Pero kung may pang-bail ka naman, yung tinatawag nilang piyansa, then you can be out and about kasi presumed and innocent ka pa naman until may final judgment. Pero as to the setting of the amount, merong factors yan na i-discuss natin later, which is na sabi ko na din naman sa CODAL, di ba? CODAL lang din naman yan. And there are times na hindi inaalaw yung bail kahit constitutional right siya because flight risk ka or yung penalty, mga ganyan. Evidence of guilt is strong, yung CODAL kanina. So, again, forms of bail, corporate surety, property bond, cash deposit, recognizance. Recognizance, ito yung hindi kailangan ng pera. Mode of securing the release of a person in custody or detention for the commission of an offense who is unable to post bail due to abject poverty. The court, where the case of such person has been filed, shall allow the release of the accused on recognizance as provided herein to the custody of the qualified member of the barangay, city or municipality where the accused resides. So, parang may custodian ka, ganun. Hindi ka magbabayad, pero may taong mananagot kapag ka hindi ka nag-appear. So, siya yung mag-ensure na mag-a-appear ka. So, RA 10389, ito yata yung sa Bar Syllabus. Yup, tama. So, goods na madidiscuss natin. Kasi ayoko nang basahin yung RA mismo. Nakakapagod kaya magbasa. So, RA 10839 guarantees the right of one deemed as an indigent to be released on recognizance except for those charged with crimes punishable by death, reclusion perpetua, or life imprisonment. Recognizance is increased in significance because of DOJ Circular Number 1, which was just issued last February 2023, which provides that all prosecutors in the department shall henceforth consider the financial capacity of the accused when recommending the amount of bail and criminal information for filing in court, in accordance with the following guidelines, and shall faithfully comply with RA 10389 or the Recognizance Act of 2012 whenever applicable. So when is a bail a matter of right? Before or after conviction but pending appeal by the first level courts. So basta nasa municipal, trial court, MCTC, METC, as a matter of right yung bail. CODAL din kanina, diba? Or before conviction by the RTC, kahit nasa RTC na siya, of an offense, as long as the offense is not punishable by death, reclusion perpetua, or life imprisonment. So as a matter of right siya. All children with conflict with the law shall be admitted to bail as a matter of right before final conviction of an offense not punishable by reclusion perpetua or life imprisonment. When bail is not a matter of right, no child charged with an offense punishable by reclusion perpetua or life imprisonment shall be admitted to bail when evidence of guilt is strong. So emphasis ha. In this case, the court shall commit the child to a youth detention home or youth rehabilitation center, or in the absence thereof to the care of a provincial, city, or municipal jail as provided for in Section 27 of this AM number 02-1-18-SC. Ito yung Rule on Juveniles in Conflict with the Law, mga CICL, which shall be responsible for the appearance of the child in court whenever required. Exceptions: the primary purpose of granting bail was to ensure that the petitioner would appear during trial and submit themselves to the jurisdiction of a proper court without denying them of their pre-trial liberty. It is not necessary to wait for the trial to finish before consideration of application for bail can be had, because there may be circumstances decisive of the issue of bail whose existence is either admitted by the prosecution or is properly the subject of judicial notice, which the courts can already consider in resolving the application for bail without awaiting the trial to finish. In the case at hand, okay, like sa case ng Enrile versus Sandigan Bayan, si Enrile, diba, the factors considered where of course his advanced age, obviously, his health, his social standing, and length of public service. So those were considered. As a rule, all persons charged with a criminal offense have the right to bail. However, persons charged with an offense punishable by reclusion perpetua or life imprisonment cannot avail of this right if ito na naman, paulit-ulit tayo kasi emphasis, if the evidence of guilt is strong. So, bail on offenses where minors are accused for purposes of recommending the amount of bail, the privileged mitigating circumstance of minority shall be considered. Where a child is detained, the court shall order the release of the minor on recognizance to his or her parents and other suitable person if hindi suitable yung parents niya or wala siyang parents. The release of the child in conflict with the law on bail, the transfer of the minor to a youth detention center kapag hindi pwede dun sa parents, or detention home or youth rehabilitation center. Exception is when the offense again involves capital offense, reclusion perpetua, or life imprisonment. Admission to bail may only be denied when, of course, again, evidence of guilt is strong. So, ano pa? Extradition proceedings. Right to bail is available only in criminal proceedings as a general rule, and does not apply to extradition proceedings, because extradition courts do not render judgments of conviction or acquittal. However, there is an exception. Upon clear and convincing evidence that once granted, the applicant will not be a flight risk or will not pose danger to the community, and that there exists special humanitarian and compelling circumstances. So, another exception to the exception. Wait lang, let me answer that. Okay, so sorry about that. Okay. Exception to the exception: when the accused is a minor, is entitled to bail regardless of whether the evidence of guilt is strong sa extradition proceedings. When not available, right to bail is not available again kapag evidence of guilt is strong and punishable by reclusion perpetua or life imprisonment. After judgment of conviction has become final, bawal na malamang kasi the purpose of bail is, pinagugutan niya presumption of innocence. Hindi mo kailangan mag-suffer ng punishment until maging final yung judgment. Gusto na namin ma-ensure yung appearance mo sa court, kaya ka namin i-detain. Yun. So, pwede kang mag-bail para hindi ka namin i-detain kasi that's the assurance of the court na mag-a-appear ka sa trial. Pero pag naging final na yung conviction, diba, kailangan mo na talagang mag-serve ng sentence, walang piyansa. Yung law, kahit mayaman ka, kung may kasalanan ka, at dapat kang makukulong at makukulong ka talaga. So, after the accused has commenced to serve his sentence, it's not available to military personnel accused under general courts martial. Iba naman yung military tribunal sa civil courts. So, meron din pala silang bail. When a matter of discretion, upon conviction by the RTC, so as a matter of right, meaning walang magagawa si court kapag pasok ka dyan sa qualifications na pwede ka mag-bail, as long as you can pay for it, then yun, magkakatalo na lang yan sa amount of bail. Matter of discretion, meaning pwedeng ma-approve or disapprove. Upon conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. Ano yung kinaiba? Kasi kapag punishable by death, reclusion perpetua, or life imprisonment, wala pa lang death penalty ngayon Kapag ka ganun yung case kasi, disallowed na talaga yung right to bail mo. Pero kung hindi naman punishable by death, reclusion perpetua, or life imprisonment, at na-convict ka na sa RTC level, like gusto mo pa mag-appeal or something, then matter of discretion siya. The application for bail may be filed in and acted upon by the RTC despite the filing of notice of appeal, provided that it has not transmitted the original record to the appellate court. So may period of time siya na pwede siyang mag-bail. If the RTC decision changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed with and resolved only by the appellate court. Doon ka mag-apply sa Court of Appeals, as the case may be. So, If the conviction by the trial court is for capital offense, the accused convicted of a capital offense is no longer entitled to bail. Kasi nga, di ba? And can only be released when the conviction is reversed by the appellate court. If the penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied bail or his bail shall be cancelled upon showing by the prosecution with notice to the accused any of the following. So, ito yung kailangan i-memorize. Okay, denied bail. Kapag ka yung imposable penalty ng charge is exceeding 6 years at recidivist siya, quasi-recidivist, habitual delinquent, may reiterasyon. If previously nag-escape from legal confinement, dating nag-commit ng evasion of sentence or violated his bail without valid justification, or commission of offense while under probation, parole, or conditional pardon. Probability of risk flight. Undue risk of commission of another crime during the pendency of the appeal. Self-explanatory na siguro kung bakit i-deny ito, di ba? Kasi walang tiwala na si court sa'yo. Meron ka ng track record na most likely pag binigyan ka ng chance na makalaya hindi ka nababalik. Upon conviction of the RTC, the bail posted earlier as a matter of right loses its force and the accused must file a new and separate petition for bail. Okay, deportation proceedings. Bail is discretionary upon the Commissioner of Immigration and Deportation. So, yun na naman yung importante sa bail. Diba? Yung RAMM na-discuss na din naman natin. Yun, Recognizance Act of 2012. So, basahin nyo na lang din kasi babasahin ko na lang din yun. So, yeah, this is quite short which is nice kasi I need to conserve my energy. Nakikinabang din naman kayo kapag nako-conserve ko yung energy ko kasi mas marami akong topics na nade-discuss. Sana may natututunan kayo. Right, study with me sesh lang to. And yan. Okay, so see you sa next video. That would be 115, Rights of the Accused. Kailangan ko pa bang i-discuss yung 115? I feel I'm gonna skip 115 kasi consti na lang. Tignan nyo na lang yung Rights of the Accused doon. Tignan ko nga. Rights of the Accused. Kung sa consti lang to. Consti lang to. Sobrang ikli. Alam nyo ilang section yung 115 sa Kodal? Alam nyo ilan? Isa. So, if ever, magbabasa ako ng isang section. Tapos, ano i-discuss ko? Consti lang. Napag-usapan na natin to sa consti. So, tignan nyo na lang yung consti. So, isi-skip ko na itong 115 pa. Itong next, 116, Arraignment and Plea. Ito yung pwede natin i-discuss. The next. Motion to quash. Yes, okay. Pre-trial. Trial. Judgment. New trial, reconsideration, appeal, provisional remedies. So, yun. Yung 115 skip pa. Okay. So, chinek ko yung bar cues. Ano lang naman yung dapat tandaan, bail, matter of right, matter of discretion. Hindi ko na siguro iisa-isahin. Alam na natin yan. Forms of bail. So, ano yung forms of bail? Cash deposit, property bond, corporate surety bond, or recognizance yung may tao nga ako sa'yo. Tapos, ang dami lang na versions ng matter of right, discretion, matter of right, discretion, ganun lang. So, i-master lang natin kung kailan matter of right, matter of discretion. Itong question na ito, maganda to. May the court require a witness to post bail? Answer is yes. The court may require a witness to post bail if he is a material witness and bail is needed to secure appearance. Pwede bang marami din questions dito. Pwede ba mag-file ng bail before arraignment? Yes. Okay? Yes. Ulit-ulit nating sinabi kanina. So, yes. Tapos kapag capital yung punishment, evidence of guilt is strong. Ayun. Yun. Sorry kung hindi ko na isa-isahin. You can have access to our questions. It's available. It's public information. It's available online. Everywhere else. Okay lang yan. It's not considered as like copyright infringement or something if kasi it's public eh. Yun. Okay. Happy aral. 116 ang next, hindi 115.